Continuing on where we left off, Understanding Company Law, Chapter 1, Regulatory Framework. Australian Securities and Investments Commission. The Australian Securities and Investments Commission, ASIC, is the main Commonwealth authority responsible for administering the Corporations Act of 2001. Prior to 1998, ASIC was called the Australian Securities Commission, ASC. As well as changing the Commission's name, ASIC was given additional functions dealing with the consumer protection and market integrity aspects of insurance and superannuation regulation. This was in line with the main recommendations of the 1997 Financial System Inquiry Final Report, also known as the Wallace Committee Report. These functions are outside the scope of this book. The Asic Act was enacted at the same time as the Corporations Act 2001 and largely reenacted the previous package of Asic legislation as a single Commonwealth law that operates in every state that referred its powers to the Commonwealth, as well as the ACT and Northern Territory. ASIC is a body corporate with between 3 and 8 government-appointed members headed by a chair. Asic Act Sections 8 to 10. ASIC must have an office and employ a regional commissioner in each referring state and territory, from Sections 95 and 96. ASIC has also established other offices and business centres in most large Australian cities. These were set up so that ASIC may better serve the needs of the business communities in the various referring states and territories. ASIC's website sets out vast amounts of valuable information, and you can look for that if you wish. Objectives of ASIC. In performing its functions and exercising its powers, Section 1 of the ASIC Act directs ASIC to strive to. There's 6 points. First point, maintain, facilitate and improve the performance of the financial system and the entities within that system in the interests of commercial certainty, reducing business costs and the efficiency and development of the economy. 2, promote the confident and informed participation of investors and consumers in the financial system. Point 3, administer the laws that confer functions and powers on it effectively and with a minimum of procedural requirements. Point 4, receive, process and store efficiently and quickly the information given to the Commission under the laws that confer functions and powers on it. Next point, ensure that information is available as soon as practicable for access by the public. And final point, take whatever action it can take and is necessary in order to enforce and give effect to the laws that confer functions and powers on it. Functions and powers of ASIC. Section 11 of the ASIC Act provides that ASIC has such functions and powers as are conferred on it or by or under the corporations legislation. Section 5 defines the term corporations legislation to mean the ASIC Act and the Corporations Act. Under Section 11, ASIC is given the following additional functions. There's 3 of these. To provide such staff and support facilities to the Takeovers Panel and the company's auditors and liquidators disciplinary board. Second, to advise the Minister about any changes to the corporations legislation, other than the excluded provisions, that in ASIC's opinion are needed to overcome or would assist in overcoming any problems that ASIC has encountered in the course of performing or exercising any of its functions and powers. And thirdly, to advise the Minister and make recommendations about corporate law reform proposals put forward by the Corporations and Markets Advisory Committee. Another acronym, KMAC. ASIC's 11 functions and powers do not apply to the excluded provisions of the corporations legislation. Section 5 defines this to mean the functions set out in Section 12A of the ASIC Act. Section 12A gives ASIC certain functions and powers in relation to insurance and superannuation, and monitoring and promoting market integrity and consumer protection in relation to the Australian financial system, as well as the payments system. ASIC's 12A functions and powers are beyond the scope of this book. ASIC is responsible to the Commonwealth Treasurer and therefore ultimately to the Commonwealth Parliament. Prior to 1996, the Commonwealth Attorney General was the responsible minister. This change was to reflect the role of corporations legislation in the economy. The Treasurer may give written directions to ASIC about the policies it should pursue and the priorities it should follow, according to Section 12. Before giving ASIC a direction, the Minister must provide the Chairman of ASIC the opportunity to discuss a proposed direction. To maintain the independence of ASIC from the executive arm of government, the Minister is not permitted to issue directions about particular cases. Registering companies. ASIC is the government authority that registers companies. As discussed below, any person who wishes to form a company must lodge an application for registration with ASIC and pay the appropriate fee. ASIC registers the company and issues a certificate of registration. Once registered, a company comes into existence and is permitted to operate in every Australian state or territory. ASCOT database. ASIC provides publicly accessible information on all Australian companies through its National Corporate Database, ASCOT. The ASCOT database contains public information about 3 points: corporations, including their names, registered offices, particulars of directors and principal activities. Secondly, registered charges granted by corporations. And finally, licensed financial service providers, for example, stockbroker and investment advisors, registered auditors and liquidators. ASCOT also provides access to ASIC's document image system, DocImage. This has digitised copies of all documents that companies are required to lodge with ASIC, such as annual returns. Any person is able to search ASCOT to obtain publicly accessible information about companies. Corporation extracts from ASCOT or copies of DocImage documents provided by ASIC are regarded, in the absence of evidence to the contrary, as proof of the information contained in them and are admissible in court proceedings as evidence without formal certification of their accuracy. That's stipulated in the Corporations Act, Section 1274B. Regulation of financial services and markets. ASIC is the main authority responsible for regulating financial products, financial services and financial markets. For example, under point 7.2 of the Corporations Act, operators of a financial market such as the Australian Securities Exchange or ASX must be licensed by ASIC. ASIC is also given the power to direct a market licensee to suspend dealings in particular securities on the ASX and to enforce compliance with the ASX's listing rules. Under point 76, financial service providers such as stockbrokers and investment advisors must be licensed by ASIC. ASIC also has broad powers to regulate fundraising by the issue of securities. For example, Chapter 6D of the Corporations Act requires a disclosure document in relation to offers or issues of securities to be lodged with ASIC before they are issued to potential investors. Section 741 gives ASIC wide power to grant exemptions in relation to the fundraising provisions. Takeovers. ASIC has an important role in regulating company takeovers. As discussed below, under point 6.5 of the Corporations Act, takeover bidders must lodge a bidder's statement and offer document with ASIC containing prescribed information before an offer is sent to a target company's shareholders. In addition, takeover target companies are also required to lodge with ASIC a target's statement containing prescribed information. The purpose of the bidders and targets statements is to ensure that shareholders of target companies receive adequate information so as to enable them to assess the merits of takeover offers. ASIC is also given broad powers to grant exemptions from or modify the application of the takeover provisions. To ensure both the spirit and the letter of the takeover provisions are complied with, Point 6.10 Division 2 enables ASIC or any person, including the bidder or target, whose interests are affected by a decision of ASIC or by unacceptable circumstances, to apply to the Takeovers Panel for an order affecting a decision of ASIC or a declaration that unacceptable circumstances have occurred in relation to an acquisition of shares. Powers of investigation. ASIC has the responsibility of ensuring compliance with the provisions of the Corporations Act. To this end, Point 3 of the Asic Act provides ASIC with wide investigatory and information gathering powers where it has reason to suspect that a contravention of a national scheme law may have been committed. For example, Section 19 of the Asic Act gives ASIC the power to require any person to give reasonable assistance and answer questions on oath where it conducts an investigation. Under Sections 28 to 39 of the Asic Act, it can compel persons to produce books and records in a wide range of circumstances. ASIC's investigations and information gathering powers are further discussed in Chapter 21. Powers to bring legal proceedings. ASIC has the power to initiate civil proceedings against a person where, as a result of an investigation or examination, it forms the opinion that it is in the public interest to do so. The proceedings may, for example, be brought in the name of a company against its directors for the recovery of damages for fraud, negligence, default, breach of duty, or other misconduct. Section 50 also enables ASIC to initiate class actions for the recovery of damages on behalf of shareholders or other persons. In addition, under Section 1330 of the Corporations Act, ASIC has the power to intervene in any legal proceedings initiated by others relating to a matter arising under the corporation's legislation. ASIC may also bring a criminal prosecution where, as a result of an investigation, it forms the opinion that a person has committed an offence against the corporation's legislation and ought to be prosecuted. ASIC's powers to begin criminal prosecutions overlap with similar powers granted to the Commonwealth Director of Public Prosecutions, the DPP. Because this overlap caused past tension between ASIC and the DPP, guidelines were established that require senior officers of ASIC and the DPP to meet regularly and review all investigations and prosecutions in which ASIC and the DPP have common interests. The guideline also requires ASIC to consult with the DPP before taking any civil enforcement action in any case where criminal proceedings may also be available. Unresolved disputes between the two organisations must be referred to the Committee for Corporate Wrongdoing for determination. Education role. ASIC performs an important educative function. It releases regulatory guides, practice notes, information booklets, and media releases so that both the public at large and the business community can more easily understand the operation of the Corporations Act and ASIC's interpretation of its provisions. Consumer protection. ASIC established FIDO, a consumer web page, which aims to provide warnings of dishonest financial schemes and advice to investors and consumers. It also includes an annual award that's called Pie in the Sky for the most outrageous financial scheme that is too good to be true. ASIC established the Consumer Advisory Panel in 1998 to advise on consumer protection issues and to give feedback on ASIC policies and activities. Shifting gear, now we're looking at the ASX. The Australian Securities Exchange Limited, ASX, operates Australia's main financial markets for equities including shares, derivatives and fixed interest securities. The ASX was formed in 1987 when the independent stock exchanges which operated in the various state capitals amalgamated. In 1998, the ASX became a public company listed on its own market. The major role of the ASX is to ensure the integrity of the market so that it operates in a fair, orderly and transparent manner. The ASX operates a number of financial markets apart from its market in equity securities. It also operates markets in derivatives and interest rate securities. The major responsibilities of the ASX include a list of 4 items: surveillance of its markets. Secondly, supervising market participants, stockbrokers. Third, admitting entities to its official list. And finally, monitoring and enforcing compliance by listed entities with its listing rules. In carrying out these responsibilities, the ASX plays an important role in corporate governance regulation. The continuous disclosure regime incorporates both legislative regulation and ASX listing rule requirements. Under the continuous disclosure obligations, listed entities must inform the ASX of any information concerning the company of which it becomes aware, which is not generally available, and which a reasonable person would expect to have a material effect on the price of the company's securities. The continuous disclosure requirements play a key role in promoting an informed and transparent market. These requirements are discussed below. The ASX formed a corporate governance council comprising 21 interested organisations, which issued its Principles of Good Corporate Governance and Best Practice Recommendations in 2003, setting out recommended best practices which listed companies must either follow or explain to the market why they have not done so. A revised and renamed Corporate Governance Principles and Recommendations was issued in 2007. There have been concerns expressed about the dual roles of the ASX as market supervisor and as a commercial entity listed on its own market. In response to these concerns, a subsidiary, ASX Market Supervision Proprietary Limited, was established with the responsibility for all of the ASX's key operational supervisory functions, providing assurance that the ASX complies with its supervisory responsibilities and overseeing supervision of listed entities where conflicts may arise because they are competitors of ASX or commercial partners. The ASX website contains valuable information about the stock market, and you can find that if you're interested. Takeovers Panel. The Takeovers Panel, called the Corporations and Securities Panel prior to March 2002, was established under the predecessor of the Asic Act 2001. While a takeover bid is on foot, the Takeovers Panel replaces the courts as the main forum for resolving disputes about takeovers. The panel was set up as the primary forum for dealing with takeover disputes to ensure such disputes can be resolved quickly by a specialist body and to prevent the various parties involved in a takeover from slowing up the process by initiating court litigation as either a defensive or aggressive takeover strategy. A person's right to commence court proceedings about a takeover bid is delayed until after the end of a takeover bid period. Only Asic or another public authority has the power to commence court proceedings in relation to a takeover bid before the end of the bid period. The Takeovers Panel is a peer review body with members appointed by the government on the basis of their knowledge or experience in business, the financial markets, law, economics and accounting. This was done so that a specialist body comprised of takeover experts attuned to the commercial realities and aware of market practices could resolve takeover disputes. The Corporations Act gives the panel broad powers in relation to takeovers. In particular, it can declare circumstances in relation to a takeover or to the control of a company to be unacceptable circumstances under Section 657A. Under Section 657D, The panel can make a wide range of remedial orders to protect the rights of any person affected by the circumstances to ensure that a takeover bid proceeds the way that it would have proceeded if the unacceptable circumstances had not occurred. The Takeovers Panel also has the power to review certain decisions of Asic to grant exemptions or modifications during the life of a takeover. The Takeovers Panel website contains information about the panel's guidance notes, media releases, decisions and rules, and you can find that if you are interested. Financial Reporting System. The financial reporting system was substantially reformed in 1999 with further amendments in 2004. The 1999 changes resulted in the establishment of new institutional arrangements for the Australian accounting standards setting process and for the adoption of new procedures to be followed by the standards setter when making or formulating accounting standards. In particular, the current provisions provide for the establishment of the Financial Reporting Council, the FRC. The FRC is an advisory body with responsibility for oversight over the process of setting Australian accounting and auditing standards. The 1999 amendments also reconstituted the Australian Accounting Standards Board, the AASB. The 2004 amendments expanded the responsibilities of the FRC to also include oversight of the new auditor independence requirements and the auditing standards setting arrangements. The Auditing and Assurance Standards Board, AUASB, was reconstituted under a chair appointed by the Minister with a similar role in standards setting to that of the AASB. Both accounting and auditing standards have the force of law. The main objects of the financial reporting system, as set out in section 224 of the Asic Act, are we have a list with 4 items. First item, to facilitate the development of accounting standards that require the provision of financial information that A, allows users to make and evaluate decisions about allocating scarce resources, and B, assists directors to discharge their obligations in relation to financial reporting, and C, is relevant to assessing performance, financial position, financing and investment, and D, is relevant and reliable, facilitates comparability, and is readily understandable. Second point. Second of the main objects of the financial reporting system, to facilitate the development of auditing and assurance standards and related guidance materials that A, provide Australian auditors with relevant and comprehensive guidance informing an opinion about and reporting on whether financial reports comply with the requirements of the Corporations Act, and B, require the preparation of auditors' reports that are reliable and readily understandable by the users of the financial reports to which they relate. Third point, to facilitate the Australian economy by reducing the cost of capital, enabling Australian entities to compete effectively overseas, and having accounting and auditing standards that are clearly stated and easy to understand. And finally, to maintain investor confidence in the Australian economy, including its capital markets. Financial Reporting Council. The FRC is an advisory body with responsibility for oversight of the process of setting Australian accounting standards, auditor independence requirements, and auditing standards setting arrangements. The FRC's functions and powers were designed to ensure that while it had broad oversight over the standards setting process, it would not be able to determine the content of particular standards. For example, the FRC does not have any direct influence over technical deliberations of the AASB and cannot veto any accounting standard made by the AASB. This is also the case with the setting of auditing standards. The FRC operates as a single oversight body for the key elements of the financial reporting framework. This aims to ensure that oversight is coherent and effective and in alignment with a common policy direction. Under Section 225, the FRC's general functions include: first, providing broad oversight of the processes for setting accounting and auditing standards in Australia. Second, monitoring the effectiveness of and advising on auditor independence requirements. Third, giving reports and advice to the Minister. And finally, establishing appropriate consultative mechanisms. The FRC appoints the members of the AASB and AUASB, other than the Chair, and has responsibility to approve and monitor the AASB's and the AUASB's priorities, business plans and budgets. Australian Accounting Standards Board. The AASB is the body that sets accounting standards. Its broad strategic plan and priorities are subject to FRC approval. In recent years, its activities have included the implementation of the FRC directive that Australia should adopt international accounting standards and interpretations. Under Section 227, the functions of the AASB include: first, developing a conceptual framework for the purpose of evaluating proposed accounting standards and international standards. Second, making and formulating accounting standards. And third, participating in the development of a single set of accounting standards for worldwide use. In performing its functions, the AASB must follow the FRC's broad strategic and general policy directions under Section 232. It must also take into account the advice and feedback on matters of general policy given by the FRC. Examples of a general policy direction include how quickly Australia should move towards greater adoption of international standards and/or market value accounting. However, the FRC does not have the power to direct the AASB in relation to the development or making of a particular standard, nor does it have the power to veto standards formulated and recommended by the AASB. The AASB is a body corporate whose members, apart from the Chair, who is appointed by the Minister, are appointed by the FRC under Section 236B. The AASB website contains information about the AASB, its media releases, newsletters and publications, and you can find that if you're interested. Auditing and Assurance Standards Board. The Auditing and Assurance Standards Board, AUASB, was established in 2004 as a Commonwealth Authority, Asic Act Section 227A. Its functions and powers largely mirror those of the AASB. The main function of the AUASB is to make the auditing standards which are given legal effect by Section 336 of the Corporations Act. The AUASB is also required to participate in and contribute to the development of a single set of auditing standards for worldwide use. Registered company auditors, irrespective of whether they are members of the accounting professional bodies, must use auditing standards when performing auditing work in accordance with the Corporations Act. Auditing standards are discussed below. The AUASB is required to follow the broad, strategic and general policy directions determined by the FRC and take into account the advice and feedback on matters of general policy given by the FRC under the Asic Act Section 234C. The FRC does not have the power to give directions on the development or making of or to veto a particular auditing standard. The Minister can give the AUASB a direction about the role of international auditing standards in the Australian auditing standards setting system after receiving and considering a report from the FRC about the desirability of giving the direction. As with the AASB, meetings of the AUASB, which are concerned with the contents of auditing standards or international auditing standards, must be held in public under Section 236E, Part 2. The Chair is appointed by the Minister and all other members are appointed by the FRC. Financial Reporting Panel. The Financial Reporting Panel, or FRP, was established to resolve disputes between ASIC and companies concerning accounting treatments in financial reports. The FRP was established as a less expensive alternative to court proceedings and allows disputes to be heard by panel members who possess accounting expertise. The FRP's hearings are informal and do not involve legal representation unless leave for representation is granted by the panel. The FRP's findings are not binding, and both ASIC and the company concerned can have the matter heard in court where the court may have regard to the FRP's findings. Companies, Auditors and Liquidators Disciplinary Board. The Companies, Auditors and Liquidators Disciplinary Board, CalDB, established under the Asic Act, is a disciplinary body which acts upon applications made to it by ASIC in respect of the conduct of registered auditors and liquidators. Its membership consists of persons selected by the government. As a result of changes introduced in 2004, hearings are conducted by panels comprising a majority of non-accountants. These amendments were introduced to address the perception held regarding the previous structure of CalDB of a lack of sufficient independence from the professional accounting bodies. Under Section 1292 of the Corporations Act, the CalDB may, on the application of ASIC, cancel or suspend the registration of a person as an auditor or a liquidator if, after conducting a hearing, it is satisfied that the person has failed to carry out adequately and properly his or his duties, or is otherwise not a fit and proper person to remain registered. The CalDB also has the power to impose monetary penalties as an alternative to cancellation or suspension of registration. Corporations and Markets Advisory Committee, CAMAC, called the Companies and Securities Advisory Committee CASAC prior to March 2002, is the main corporate law reform advisory body of the Corporations Act scheme. Under Section 148 of the Asic Act, CAMAC's primary function is to advise and make recommendations to the government on any matter connected with the operation, administration and reform of the corporation's legislation. CAMAC can also make recommendations regarding the financial products industry and the financial services industry, as well as proposals for improving the efficiency of the financial markets. CAMAC and its predecessor CASAC have produced a large number of reports and discussion papers dealing with a variety of topics. The Lipton Herzberg Law Reform site has links to these reports. Parliamentary Joint Committee on Corporations and Financial Services. Part 14 of the Asic Act provides for the appointment of a Parliamentary Joint Committee on Corporations and Financial Services, PJC, at the commencement of the first session of each Parliament. Prior to March 2002, the PJC was called the Parliamentary Joint Committee on Corporations and Securities. The PJC consists of 10 members of the Commonwealth Parliament, 5 of whom are senators appointed by the Senate, and 5 who are members of the House of Representatives appointed by that House. The Commonwealth Treasurer is the minister responsible for the political supervision of both ASIC and the corporation's legislation. The purpose of the PJC is to add an additional level of parliamentary supervision over the Corporations Act scheme. According to Section 243 of the Asic Act, the duties of the PJC are to inquire and report into the operation of the corporation's legislation generally, ASIC and the Takeovers Panel. Recent reforms. In recent times, there have been numerous amendments to the legislation. These amendments have aimed to modernise corporate regulation by simplifying the law, making it more efficient, and also responding to recommendations of law reform bodies after deficiencies were identified. There are several bodies which put forward corporate law reform proposals. These include Asic, the Corporations and Markets Advisory Committee, CAMAC, the Parliamentary Joint Committee on Corporations and Financial Services, PJC, and the Australian Law Reform Commission, ALRC. The most recent amending legislation includes: first, Corporations Legislation Amendment, Simpler Regulatory System Act of 2007, which contains a range of measures to simplify and streamline Australia's corporate and financial services laws in order to reduce regulatory burdens and compliance costs. These amendments include reducing the regulatory burden on providers of financial services, simplifying company reporting obligations, improving the auditor independence rules, removing unnecessary member approval requirements in relation to small transactions between public companies and related parties, and facilitating fundraisings. Second, Corporations Amendment Insolvency Act of 2007, which includes a range of measures intended to modernise Australia's insolvency laws by adopting a large number of recommendations of several law reform reviews and inquiries. The reforms introduced in this legislation deal with strengthening creditor protections, deterring misconduct by company officers, improving the regulation of insolvency practitioners, and fine-tuning voluntary administration. Finally, Corporations Amendment Takeovers Act 2007, which implements amendments that are designed to allow the panel to continue to effectively act as the primary forum for resolving disputes during takeover bid periods, so that the outcome of any takeover bid can be resolved by the target shareholders on the basis of its commercial merits. These amendments were a response to two cases which interpreted the powers and jurisdiction of the panel in narrow terms and raised concerns that it would be unable to effectively perform its intended role. And that is the end of the chapter.